Tantular against His Majesty, Attorney General.
Yes,
Well, my lords, this appeal, of course, raises a fairly narrow point, although not without its complexities, as the courts below found. The short point is whether a saisie judiciaire over property that is subject to a legal mortgage can prevent at least some assignments by the mortgagee of its rights under the mortgage without reference to the court granting the saisie. In other words, without applying for a variation. That's the issue that was raised. And very quickly, the background to it was, as your Lordship and Ladyship know, the grant of the saisie judiciaire, which attached to the realisable property set out in the order. And it's probably just as well to have a quick look at the order, because they're in standard form. It's an electronic bundle, starts at page 12.
And are we going to work from the 9th of August 2013 one? So,
yes, apparently they're in identical terms, as Sir Lordship says later on. Because this is the saisie which the bank concerned had notice of. Now, there are three features of it which obviously mean that it was perhaps drafted with less precision than it could have been. The first is in the first paragraph. It says, pursuant to the law, and it sets out, it says, a saisie judiciaire is granted in respect to the realisable property situated in Jersey of Robert Tantular, and then it sets out whether movable, immovable, vested or contingent, and then without prejudice to the generality of the foregain, to include assets held by the BOS Trust Company, and so on. And if you look down, as trustee of the Jasmine Investment Trust, then there are further definitions. If we go to the rest, under 2, little Roman 2, the prohibition that the trustee be prohibited from dealing with any realisable property of Tantular present held or transferred to it after the making of the present order. And then there's a recital that thereafter the Viscount be directed to take possession of all the realisable property situated in Jersey of Tantular to manage the same. And then 4, showing that the trustees, under the directions of the court, the BOS be permitted to manage or otherwise deal with the assets of the Jasmine Investment Trust under the direction of the Viscount. And where the bank comes in is in 6, where we can see the Viscount has to give notice of the present order, and then there are a whole series of people. Now, the bank's not named, but at the very last sentence, notice has to be given to any other person appearing in him to be affected thereby. And of course, plainly, the bank under the mortgage would be affected thereby.
So just on the form of the that says it, although there's a direct order directed to BOS,
yes,
little 2, that it be prohibited. I mean, there isn't a direct order against Mr. Tantular, for example.
So,
against Mr. Tantular, for example.
So it seems to the reason.
It seems to operate on the basis that the order identifies property.
Yes.
Says that the Viscount, in effect, may take control of that property.
Yes.
And then, presumably, in relation to persons who have interests in that property,
yes,
they're bound. Well, are they bound directly by the order, or are they bound by operation of principles of taking care not to frustrate the effect of the order?
The latter, if they're not in the order.
Right.
But actually, on its face, the order only covers Mr. Tantular's property situated in Jersey. So it's patently defective, really.
That's why I opened it and said it should be. It is defective in that regard.
Well, has nobody ever done anything about that, or they just proceeded on the basis of an order that doesn't actually have the scope that
Well, it
We're arguing
appears,
about on this appeal.
that appears to be the position. Everyone appears to have operated on the basis and kept going, which now obviously the solution would be to go back to the Royal Court and ask for an amendment of the order.
Well, you're representing the Attorney General,
Yes.
so, you know, it's not just some extraneous fact as far
No,
as
it's
your
not.
client's concerned.
No, I accept that. It's badly drafted and something should have been done about it.
I suppose you could say, well, that there is a certain, I'm not sure ambiguity is the right word, but tension on the face of it, because
Yes.
although it's restricted in that way in the opening words, it then refers to a range of property
Yes.
which may
However, that's all included, meant to be included,
I know.
Yes.
without prejudice to the generality.
Yeah. I mean, I'm not suggesting it ought not to be corrected, but everyone has proceeded on the basis that it does extend more widely, and I suppose one can see that there is a basis for that assumption having been made.
Yes.
But the realisable property situate in Jersey of Robert Tantular, which seems to echo 16.4a, is not actually the basis on which the apartment in Singapore is treated as realisable property. It's treated, as I understand, because it was a gift from Mr. Tantular to the trust.
Yes.
To the trust, and thence to John Zell.
Yes.
That's right.
So it's but
It
that
is
presumably was all
The question is
discovered after
Yes.
the SESI was
Yes.
granted. But it
the,
wasn't corrected in the second SESI. That's the curious thing.
No, that is again.
There were judicial decisions about this one.
Yeah, there were. Yes. If one looks at Little Roman 2, it may be that would, sorry, 2 rather, that save to the extent envisaged by paragraph 4 below, the trustee be prohibited from dealing with any realisable property of Tantular at present held by it or transferred to it after the making of the order. But there is certainly happy drafting in this document, and I accept that.
But I'm so sorry, just to follow on from Lord Hamlin's point. I'm afraid I hadn't been back through all the decisions.
No,
So what had been the decision? Had this issue of construction arisen previously and then been resolved by the court?
It hadn't been resolved.
Right. So what decisions are we talking about?
The first decision, there were a number of variation applications, but the first decision of any substance was the bank intervening and applying to vary the SESI so that it could exercise its power of sale over the property. And if we go to the electronic bundle at 96, you can see the application put in by the bank.
I'm so sorry, which page?
96.
So there at 19, they say, we understand that the shares
Yes.
are subject to the terms of the two SESI.
Yes, that's the basis.
On what basis they understood that is a bit of a mystery.
Well, the problem is that they certainly seem to have acted it on that basis.
Yeah.
And then we can see that the paragraph 20 wishes to realise its security over Cusgarden Road property, wishes to apply to the Royal Court to vary the SESI judiciaire. Following sale of the property, the representor agrees to remit the net proceeds of sale to the Viscount after deduction, of course, of all necessary expenses. Now, in relation to that, there was a hearing which took place, and the variation was actually granted.
So where do we have the order from that hearing?
It's just below.
Oh, is it?
Well, that's the order of question.
Yes. The actual order is 260.
Thank you.
Presumably, if somebody had taken the point at this stage.
No, I'm so sorry, 260 is not right, I think.
It's in the middle of scrolling down. No, the order is page 99 and 100. It's just that the start of all these orders is a...
Sorry, 99 you're now saying is the order.
There's a recital of the application, and then you get on page 100 the variation. It's number 1 on page 100 that says here, judiciaire in respect to the realisable property hereby varied so as to permit a sale free of the saisie judiciaire by the representative of the property insofar as may be permitted under the facility and or the mortgage as governed by and at all times subject to Singapore law. And then there's the provisions about what happens to the net proceeds of sale.
Right.
So that was the first really substantive, and the judgment of the court follows on just below, starting at page 102. And an issue germane to this issue did arise in this hearing. If one goes towards the end of it, the bailiff sets out the background. Paragraph 10 on page 104, he states what the application before him was, which is the variation application. Then he deals...
Was this opposed by anyone?
It was... the variation wasn't necessarily opposed, but there were certain conditions that were sought to be attached to it, in the sense that there is one paragraph, and that's just drawn.
And can I just check which parties were before the court arguing?
The bank, the Attorney General, and the representing the beneficiaries of the trust, who were resident in the property, obviously, Cusgarden Road.
Right, so in effect,
paragraph 11, it tells you.
All relevant parties
Yes.
were before the court and arguing about this at that time, is that right?
If you look at paragraph, that's right. It says the Attorney General, the Viscount and the trustee did not oppose the relief sought by the bank. Advocate Hanson, on behalf of the interveners who are the beneficiary, raised 4 points for consideration.
I suppose the order at page 99 is, or 100 is wrong, because it's not the realisable property of Mr. Robert Tantular at all. It's a realisable property of the company.
Yes. I think the confusion may have arisen at this stage, because this was at a stage where the submission was being made that the entire trust property was realisable property. Now, that was later adjudicated on in a separate judgment, and the notion that the interests of beneficiaries, like Mr. Tantular, under discretionary trust, could be realisable property, the judge said, no, they can't be, because he doesn't have an interest, only the right to be considered for a distribution by the trustees.
I suppose realisable property of Robert Tantular is really being treated as equivalent to realisable property in respect of Robert Tantular, yes. Because in order for it to be realisable property at all, you have to trace it back to him, yes, even though it could be property owned, yes, by someone else, but it's still realisable property for the purposes of the modified law.
Yes. And just to continue, the 4 points raised by Mr. Hanson are mentioned. The first one was to do with Article 16.5, which is set out actually in paragraph 14, so we don't need to, but what 16.5 2008 modified law says, any property vesting in the Viscount pursuant to paragraph 4A, so that's property situated in Jersey, shall so vest, subject to all hypothecs and security interests with which such property was burdened prior to the vesting. Now, of course, here we had a mortgage over a property in Singapore, which is not within Jersey law a hypothec or a security interest. So Advocate Hanson raised this, and you can see that in paragraph 16, saying that, of course, a mortgage does not constitute a hypothek, which is a limited expression. He gives the law in Jersey, which relates to that. A security interest, similarly, is clearly referred back to the Security Interest Jersey Law 2012, or its predecessor. So what was being said was, well, the mortgage over the property, which was held by Credit Suisse, did not fall within either of those categories. How was it to be dealt with? And we can see there was no full argument, but paragraph 17, we've not heard full argument on this aspect. And although Crown Advocate Bullon was inclined to agree with Advocate Hanson's submission, he wished to reserve his position for any future occasion where the point arose. Nevertheless, as at present advised, we are inclined to agree with Advocate Hanson. Accordingly, we assume for present purposes that the whole of the property is caught by the Saisies, and it is necessary to consider the power to vary under Article 16(6). So what the judge was saying was, well, the property is not neatly divided into separate bits. The realisable property is the whole property, but subject to the third-party interest created by the mortgage. And if you scroll down, he then dealt with that.
But I thought that he was saying that it's not, that because the mortgage doesn't fall within 16(5), the vesting is not subject to that encumbrance, because 16(5) only provides for the property to be subject to hypotheks and security interests, and this isn't one of them.
Yes. I was just going to add the way, maybe I read that wrongly, what he was saying, but I think the submission...
That's why they say that the whole of the property is caught.
Yes. That's what he said. But the qualification is in paragraph 18, where he says the principle underlying Article 16(5) is clear. What is intended to be caught by a Saisi and to be available for confiscation in the event of registration of an external confiscation order is the equity in the asset. The operation of the modified law is not intended to prejudice the position of a bona fide lender, such as a bank which held security over the asset in question. Lenders such as banks should be able to realise their security and obtain repayment of what they owed, with only the equity in the property remaining available for confiscation. Similarly, when property is being realised by the Viscount, the court should exercise its power under Article 21 to direct that the bank should first be paid out of the sale proceeds, with only the balance reflecting the offender's equity in the property being applied towards satisfaction of any external confiscation order. And then 19, it follows that in our judgment, the starting point, where the court is satisfied that the application is being made by a bona fide arm's length third party with security over foreign property, which is subject to a Saisi, should be that the Saisi should be varied so as to allow the secured party to enforce its security in accordance with its terms. We see no reason not to adopt that approach in the present case. John Zell is in default. The bank has been seeking to recover its money for some time. It should now be permitted to realise its security over the property in accordance with such rights as it has under the documents creating the mortgage in Singapore law. And then the other points raised by Advocate Hanson, perhaps not germane, possible excessive recovery by the bank and some provision. The order was...
You agree with that approach? You don't challenge that approach?
No, we don't. No. But it caused the... this is where some of the dicta in the Court of Appeal come in, because it goes back to this approach by the judge.
But it's inherent in paragraph 19, that if the court was not satisfied that the application was being made by a bona fide arm's length third party, they would be able to refuse the variation of the saisie.
Exactly.
But from where does that ability come from?
Well, one has to look at what is the purpose of the saisie. Is it to, as we would submit, to secure the property, to make it available eventually for enforcement? If what is proposed by someone is going to materially affect that issue as to what property is available, then of course the court can refuse the variation.
Well, you say of course, but what I want to understand a bit more is what is the legal basis on which the court refuses that?
Well, if we go back to the actual law, which I think is Article 16, we go back, it gives the powers, but in summary, what it says is that the imposing a saisie, the court can impose such conditions as it thinks fit. So it's a flexible remedy. The purpose, obviously, of the saisie is to preserve the property.
Yes, I know. You keep saying that. We know that that's the case, but what's the legal reasoning behind the court's ability to refuse to allow a mortgagee to exercise the power of sale?
It's the case, generally speaking, you're right, the mortgagee can exercise his powers without going back to court for variation. But there is an exception to that, which is in a case called Gangway and a couple of other cases we've cited, which indicate that in circumstances where there may be suggestions of collusion or fraud, then the court does have a jurisdiction to consider the matter. That seems, it's a narrow exception. The court says in the normal course of events, and there's a dispute between two cases. One case says the mortgagee must go to the court anyway to ask for authority. The later case, which is Mr. Justice Mann, says no, the mortgagee doesn't need to do that, but then qualifies it by saying that if there may be an issue of fraud or collusion, well, the mortgagee can come to court and ask for the court's blessing.
And doesn't this go back to what I understood to be your submission, that the basis on which persons who are not subject to a direct order prohibiting them from doing any particular thing,
Yes.
and as I pointed out, Mr. Tantular isn't directly prohibited from doing any particular thing, their liability to contempt, potentially, is based on a principle of non-frustration
Of the order.
of the order,
Yes.
rather than directly on
Yes.
the terms of the order aimed at them or covering them.
Yes, that is that, yes.
And isn't that ultimately the basis for the Gangway exception?
It is, yes.
That if it's just a regular security transaction and dealing between bona fide banks where it's not going to affect whatever equity is left in the property for realisation, there's no basis for saying that the parties to such a transaction are acting to frustrate the forming of the order.
Yes, because the injunction doesn't give any priority to the claimant.
So the position is, if the bank doesn't go and get the variation and just makes the transfer, the risk for the bank is it may be in contempt of the order. It may not be, in which case, if the contempt proceeding is brought, it may fail.
Exactly.
However, if the bank's concerned about that, it can go along and get a variation just to make sure that it's not at risk of being in contempt.
That's the point. And of course, when one's dealing with a confiscation order, the bank is likely to be even more wary because it involves criminal conduct somewhere along the line and possibly the proceeds of crime. The bank won't know the full details, obviously. So they are likely, in a situation which later emerged to want to go to the court to get the court's blessing to cover any potential liability they may have. So that's the very narrow point. And
But is the bank seeking a variation of the order in such circumstances, or is it seeking the court's a declaration or from the court that it wouldn't be in contempt if it did certain things?
well, it seems to have taken the view in this case.
Well, it took the view in this case, but I was asking you what the correct view is. But,
It would seek a declaration, I suspect.
yeah, well, because there wasn't any term of this order that impacted the bank.
There wasn't?
There wasn't a direct order to the
No,
bank.
there wasn't. The
No.
bank had notice of the order as...
Yes.
yes.
I suppose you could reason this or cover yourself from the bank's perspective in two ways. That it's almost for the avoidance of doubt.
Yes. Yes.
This order will not catch on any basis the bank acting in these circumstances. Although my Lord Stevens is probably technically correct that if the basis
Yes.
for the bank potentially being liable in contempt is a non-frustration principle, and on the facts it's not going to frustrate, one could simply, perhaps, as a bank, seek a declaration saying, if you act in these ways, you will not have frustrated and therefore will have no liability.
Yes, rather than applying for variation. Like
Well, that takes me to the orders that could be made under 16(4)
yes.
against the bank. I want to make absolutely certain I understand your case. There was, in fact, no order under 16(4).
No, there wasn't any order.
Okay. And secondly, the specified person would be the bank, all right?
Not
If you were making an order,
if
you were making an order, it would be the bank.
Person,
Right. And what realisable property does the bank hold?
yes. It's essentially the equity. The bank.
Yes.
Yes, the equity in the property.
How does it hold
The
that?
bank doesn't hold that, so you couldn't get that order.
Oh, well,
I thought you'd accepted that the equity in the property, that the bank doesn't hold realisable
No,
property.
the bank has the debt,
yes.
has the rights under
Yes.
the loan,
Yes.
and it also has a charge over the property.
Yes. But obviously the operation of that may affect the value of the realisable property.
Well, it may, but you couldn't get an order
No, I'm
against
sorry,
the
I
bank
wouldn't
directly, could you?
No, I accept that.
So again, doesn't the basis on
Comes
which
back
the
to
bank
basis.
could be
Yes.
liable, essentially in contempt in respect of the
Yes.
SESI, is on this frustration principle,
Yes.
not because it is bound directly by
It's not
the
bound.
terms
No.
of the order attaching to property in its hands.
Yes. That's quite
That's it. Right. Okay.
And then, following that, just take...
Okay, sorry, just before we move on from the order and judgment that you were showing us, am I right in thinking that there wasn't an appeal?
No, not on this.
Right.
So the sale was proceeding through in, proceed through in Singapore.
Well, just taking it on a little bit in relation to 16(4)(b. Assume for one moment that the bank wasn't wishing to assign, but was wanting to exercise its power of sale.
Yes.
Its power of sale would be dealing with the equitable interest.
Yes.
Insofar as how it sells a property would impact on how the value of the equitable interest.
Yes.
And indeed, they would deal with it because the money would come into their hands
It
because
would,
when they
and
sell
then-
the property.
Yes. And then they
So-
have to pay out and so on.
There may be a distinction between, you potentially could obtain an order against the bank prohibiting them from selling.
Yes. But of course, we then reached the crux of the case. It was what was proposed wasn't a sale.
And if you get an order prohibiting the bank from selling, it might be a little bit difficult for somebody to assign that interest to
Yes,
somebody else.
certainly.
And anyway,
Yes. As your lordship observed, the next stage was that variation having been granted, there was then the application that came before the courts. And if one see the first version of it, which arrived, stated, it's on page 112. So a summons was taken out that the Royal Court declare that the saisie justiciae imposed upon the realisable property of Mr. Robert Tantular do not prevent Credit Suisse assigning to a third party its rights under the credit facility dated 9th of June 2008 and the legal mortgage secured on the property on 26 Cuscaden Road. And this is how the issue then arose.
And just in terms of the chronology, is this application taken out because at this stage the bank is indicating that it's not willing to proceed
Yes, and
on its own risk? So the beneficiaries
Yes.
are essentially seeking an order from the court saying
that seems to be
you're completely in the clear. The bank is completely in the clear, and that would enable them then to go back to the bank and say
Yes, because of course what had happened in the meantime was I don't think they'd actually done it, but they'd asked for vacant possession of the property, so something had to be done so the beneficiaries could stay there. So this idea of assigning the legal mortgage to a friend of theirs seems to have emerged. But the bank actually, when confronted with it, wouldn't go through with it. They said very firmly that before they even considered that proposition, the beneficiaries, was the way they put it, had to get the consent of the Royal Court.
Sorry, you're referring to something. Can you give us the page?
If you just give me a moment. It's 688 is the bank letter where this emerged.
And that's dated
23rd of April 2019.
So the bank was proposing to take possession and sell the property.
Yes.
It was then presented with this offer
Yes.
of assignment, and it said, well, we'll only agree if you get the blessing of the Royal Court for this.
Yes. Well, in fact, they went a bit further than that. So we'll only consider the position if we get the blessing of the Royal Court.
But just looking at the letter, it says the bank has been provided with the beneficiary's summons.
Yes.
So
that's what we just looked at.
yeah, sorry, I thought you had told me in relation to the chronology that the bank had somehow indicated that it wasn't prepared to proceed.
I think this proposal had emerged before the summons, but anyway.
Yeah, that's what I was asking
Yes.
for. Can you help us with the page?
No,
for that?
I can't.
Presumably setting out its formal position here
Yes.
so that everybody could see what it was.
Yes.
Okay.
I think this letter was to be put before the court. Yes.
But again, page 692, a bit later on, 8th of May 2019, they repeated that they would only consider entering into the action that is approved by a Jersey court now.
So, I mean, that's a bank being typically cautious in
It's being
relation
cautious,
to these
yes.
things. It doesn't want to take any risk.
Didn't want to take any risk. But the upshot was, this is what led to the Royal Court and the application made for the declarations.
Well, strictly, it didn't lead to the applications because they've been filed already, but
Yes.
it led to them being pressed in court.
But is there anywhere where the bank sets out what it thinks the risk is? I think
No.
where we've got to is that the risk was not of it directly being in breach of
No. No, the bank never seems to have set out in terms why it wasn't keen to do the
but
assignment.
I think where we've got to is that the risk was that it might be held to be in contempt for frustrating the order rather than it personally being in breach of the terms of
That's as I understand it, yes. Obviously, the Attorney General, when he learned of the proposal, was concerned. And so the matter then came before the Royal Court for a hearing. 114 is the Royal Court ruling. Just perhaps.
So that's the Royal Court ruling in
this
yes. Appeal.
Yes. So if we just go back.
Yes.
So I'm not going to go through, obviously, all of it. He recites the background, recites the various arguments that are being put forward. But we go right down, scroll right down. He deals with the principle which the previous judge had dealt with, namely that this was a mortgage outside the ambit of the security interests in Article 16.5. That's on page 118. And then the arguments are then set out. So, applicant's case, and this is Advocate Hanson. Paragraph 13, it is on the page. The central case put forward by Advocate Hanson is the fact that the mortgage does not form part of the realisable property of the settlor, and he said the bank is free to dispose of it as it wishes. It can do so without reference to John Zell or to the court. And he contrasts that with what happened with the application to vary for the power of sale. The application by the bank to the court last year was required because the bank intended to exercise its power of sale over the property, which did form part of the realisable property of the settlor. There's no sale proposed here, merely a change in the identity of the lender.
Again, I mean,
you accept all this, don't you? You accept this proposition, that the central case put forward, that the bank is free to dispose of it as it wishes?
No.
I thought you said it was. It just might be in contempt if it doesn't get the blessing of the court. There's nothing in the order that prevents it.
No, there's nothing. I apologise. The answer is the bank can do that, save in the very narrow circumstances which the gangway case and the other.
You accept the mortgage doesn't form part of the realisable property, don't you?
Well, it can't be.
Yeah.
Yes.
Sorry, I was just going to raise a slightly different point, just to observe that the slight slippage or ambiguity in the language again used here. Part of the realisable property of the settlor is really realisable property in respect of
the settlor,
because it catches both property strictly of the settlor, but also of third parties.
Yes.
But just to check your acceptance that this is right is not simply because of the way this particular SESI was drafted. It's that the mortgage could not be realisable property.
No, the problem obviously is this. The confiscation could not confiscate the bank's interest. We accept that.
Yes.
It's not realisable property in that sense. But the trouble is, at the SESI stage, obviously it's attached to what is realisable property. And the conundrum is, what do? Do you take out a knife, as it were, and try and cut the property in two? Or do you, as the law perhaps suggests, that the whole property is frozen, but subject to the rights of the mortgage holder or the holder of the hypothec or the security?
You seem to be changing your position now. I thought your position was that it was not realisable property in the mortgage. It's not covered by the order.
No, the mortgage is.
No variation is needed, but if the bank goes ahead, it may be taking a risk
Yes.
of contempt, which may be
Yes.
why it needs to come and get a declaration.
Yes. Yeah.
So that is the way you're putting it.
Yes.
We just want to be
Yeah,
clear.
sorry.
And the
Mr. Cousins needs to be clear.
the only occasion on which the bank holds realisable property is when it's actually sold.
Yes, when it's got the proceeds
and
in.
has got the proceeds.
Yeah. Yeah. But obviously, the point here, which was at the heart of this, was this submission, and that was in fact rejected by the learned commissioner. And just going through this.
And tell me, just the contempt proceedings, can they encompass compensation? Insofar as if the bank sells, and by chance you can enforce contempt proceedings against them, say the bank is assigned in such circumstances that there is a massive loss to the equitable interest, because they've assigned to somebody, not in this case, but somebody who's a criminal.
Yes.
And so what's the remedy there? The bank have acted in a way which has put at risk the security.
Yes.
Okay? Put at risk, and in contempt of court, because they've done it quite deliberately, I
Yes.
assume. So what's the remedy?
Barclays case.
What's the remedy?
The Barclays case suggests that there isn't a remedy. There's no common law claim for damages for negligence arising from that. So,
Very painful defeat of mine.
yeah. But yes, there's
But, I mean, we're talking about the law of Jersey here.
Yes.
I mean, is Barclays necessarily applicable in Jersey?
I'd have to look up.
Right. Well, perhaps we should be a bit cautious about accepting your answer that,
Yes.
that there clearly is.
Certainly under English law.
But the reality is that all that the only protection is the caution of the bank and wanting to come and not being willing to proceed without
Yes.
a blessing from the court, and
Yes.
then the court may not give that, in which case that's all that impedes the transaction.
Yes, that's true. Yes.
If it chooses to take a risk, the bank there would be nothing you could do about it.
No, that's right. It's only because the bank.
Bring contempt proceedings potentially.
That's only because the bank here had made it clear to the court it wasn't going to do anything without the express consent of the court that the issue arose. Said, well, it was a foreign bank and had submitted to the jurisdiction.
And obviously the beneficiaries couldn't force this transaction on the bank. They needed its consent in order for it to work.
Yes.
So it's purely a matter of the bank's own judgment of its self-interest, whether
Yes.
it will give consent or not.
Yes. So the contention, as I say, was in fact rejected, and the Royal Court decided that Saysies did prevent the assignment. I mean, the point that it wasn't the Saysies that necessarily prevented the assignment, but that it was the bank's notice of the order and frustration of the purpose doesn't seem to have been taken.
So you're not defending that part of the court's reasoning, as I understand it?
I mean, obviously, as to the merits, assuming the bank, the court did have jurisdiction, of course, it was pointed out that the circumstances of the transaction were such that no discretion would have been exercised to allow it to be carried out. So that was the decision of the commissioner, and then it went to the Court of Appeal.
So, sorry, before we move on from this, my Lord Legate was saying you don't defend that part of the reason. I'm just trying to identify which part that is, because I'm looking at the quite lengthy submissions on both sides set out. And then I was looking at paragraph 33.
It's 32, 33 onwards, yes.
Because paragraph 33 seems to be based on the idea of frustration of the order. where the bank has notice.
Yes.
Sorry, but am I misreading it?
No, we agree that the prohibition against dealing addressed to the trustee, and which is binding on those with notice of it, such as the bank. So it did, but it's 32, which.
So 32, the judge seems to be looking to the intended effect of the SESI, which is to preserve assets and the value of those assets for confiscation purposes. And then 33, he seems to be identifying the basis on which a bank could be liable under the SESI, that is to say for contempt, as being based on the notice they have of that order. Am I reading it correctly?
No,
I think it's paragraph 34.
The 34 was the paragraph
I was asking you if
it was
or not.
Yes.
Right, but you don't defend it insofar as the reasoning is giving a very extended definition to dealing with the flat.
No, I don't. No.
That this would amount to dealing in some legitimately extended version of that.
The only way you could say it would be dealing is what it's dealing in the property, because it's changing the identity of the person holding the charge over the property. That's as far as you could go.
But it's not dealing with property held by the bank.
No. Well, then we go to the Court of Appeal judgment, which is 225 in the bundle. And again, I'm not going to go through all of it. It sets out the background and the rival contentions, perhaps. Deals, though, with the ultimate issue quite shortly. The first part of the judgment, I should add, was taken up with the question of whether all this was academic, because the bank had, in the meantime, said whatever happened, they were not going to go through with the assignment. They were pursuing their remedy of sale. So the actual judgment starts at paragraph 43 on page 236. So the court then went through the various statutory provisions. It's perhaps paragraph 48, that's 49, that are part of the core reasoning. This is when I mentioned earlier at the outset that there'd been an allegation that the whole of the property was realisable. That was rejected. And then the sentence, material parts subsequently, as we've said, the Royal Court concluded that the property held by Jasmine, the value of £1.6 million approximately, was a realisable property and subject to the SESI, see paragraph 8. When the second SESI was the subject of litigation, the court, on the grounds primarily that its continuation would constitute an abuse of process, the Royal Court dismissed that challenge, holding to that it applied to the property held by the third respondent, with no specific limitation as to amount. Again, the court proceeded on the basis that Article 2(1)(b)(2) was satisfied, and that property held by Jasmine constituted realisable property. However, whilst those decisions determined that the SESI had been made validly and that Jasmine held realisable property, which is subject to the SESIs, they did not definitively determine the ambit of the realisable property. And then in paragraph 43, the court says, it's back to the point which it started with the very early judgment, they say, with the benefit of hindsight, an opportunity to determine the nature and extent of the realisable property, which was the subject of each SASE, presented itself upon the bank's application in 2018 to vary the terms thereof, so as to permit it to exercise its power of sale over the property. However, it seems clear to us that far from determining the nature and extent of the realisable property, which was the subject of the two SASEs, the Royal Court proceeded upon an assumption that the property, which was the subject to those orders, was the property including the mortgage over it. In the words of the Royal Court, we assume for the present purposes that the whole of the property is caught by the SASEs, see paragraph 17. And then they say against that background, they consider the appeal. Various arguments are summarised. It's worth stressing that although Advocate Hanson made it clear that he did not consider that an assignment of the interest in the mortgage could constitute dealing, which was the realisable property, appears to have accepted the bank's application to vary it. And then he recites that. Paragraph 34 of the judgment, which my Lord referred to, they look at that. And then they say this: in our judgment, the finding of the Royal Court is that the realisable property, which is the subject of the SASEs, comprises not just the property itself, but also the mortgage to which it's subject. It seems to us that this is the only proper conclusion to be reached from the language used in paragraph 2. No doubt, too, this conclusion flowed from the Court's understanding of what had occurred before the Royal Court on the bank's application to vary in 2018. And they say that 54, we find ourselves unable to agree with the reasoning of the Royal Court. In our judgment, reasoning conflates the ownership of the legal estate and the mortgage property with the legal interest which a mortgagee enjoys in the mortgage over the property. In the instant case, the legal estate in the property is held by John Zell. The interest in the mortgage over the property is held by the bank. In the absence of very clear words within the SASEs themselves, together with the statutory basis found in the 1999 law, we cannot conclude that both the legal estate in the property and the bank's interest in the mortgage together constitute the realisable property, which is subject to the SASEs. We say that not least because if both together comprise the realisable property, it would mean that in many cases both the property itself and any encumbrances over it would vest in the second defendant, the Viscount, obviously, by virtue of Article 16.4.1 of the 1999 law. This would put her in a very difficult position of having to juggle her duties and powers as the Viscount, the duties and powers of a mortgagee. Then it says that's avoided by Article 16.5 for hypertext and security interests governed by the law of Jersey. But as we see it, it would arise in respect of mortgages or other securities governed by laws of other jurisdictions if property and mortgages over it are treated as if they were one and the same. We do not accept that that is what the 1919 law intended. So on that basis, and referring in paragraph 56 to the case of JCPC Bank and Ablizov, they concluded, therefore, an assignment to the bank's interest in the mortgage over the property would not constitute dealing with any realisable property which is the subject of either SASE.
So I mean, just on that, I mean, it might be said that there's a degree of confusion in the reasoning of the Royal Court, because we saw the difference between paragraphs 32 and 33, and then 34, which made it sound like it was all about interpretation of the SESI, whereas 32 and 33 are based on a non-frustration doctrine. Here, the Court of Appeal is agreeing that there is a non-frustration doctrine, as I understand it, because that's the significance of, I think, JSC Bank and Abliazov.
Yes, and they also cited O'Brien.
But then they seem to go back to, and although they accept that the property itself is realisable property, I mean, they say of Robert Tantular, but again, I would say in respect of Robert Tantular, they then seem to base their judgment on whether there's dealing with the security in.
Yes, they do. Yes. Yes. So they say the assignment is not dealing with the property, and therefore no application to vary needed. That's the.
So that
And you don't dispute that, as I understand it, but you say it doesn't follow that the applicants are entitled to a declaration.
That's why you say
they sought.
yes.
I mean, in effect, as I understand it, the way you're putting your case, it's that the Court of Appeal has not correctly understood the application of the frustration principle and how it would bear upon the bank.
Yes, they've looked at the narrow issue. Was that dealing within the terms of the SASE?
Yes. Right.
So that is our contention, yes. And then finally, in this regard, perhaps we can look at one. I'm conscious I'm coming near to my time, but can we go to the one case which summarises the relevant principles, Taylor and Van Dutch, which is electronic bundle 3210, because it summarises the earlier case as well.
Yes.
Now, we don't, in essence, need to go to the facts. It was the claimants have obviously been granted a freezing order over some of the defendants, which was to prevent them from dissipating their assets, which included boats and so on. But there were prior charges over some of the property. And so the issue arose as to whether the court needed to endorse the action taken by the holders of the charge. And we can go very quickly to the principles, which the court explained. It's paragraph 12, which is where it starts. So what the judge says is, Justice Mann, thus in my view, a third party with security over property which is frozen by the freezing order would not need to obtain permission in order to exercise that security, because the exercise of the disposal rights under that security would not be an act prohibited by the order. If, for example, the third party uses a power of sale in order to dispose of the property, that would not be disposal by the defendant, notwithstanding any technicality which might arise out of the fact, which is common to many securities, that the exercise of power of sale is technically done as agent for the mortgagor, and so on. He says the enforcement by the mortgagor would not be an infringement of the letter of the order, nor would it be contrary to the spirit of the order, which, as I have explained, does not operate so as to give the claimant a prior right and form security over the assets. If the freezing order does not destroy or affect the rights of a chargee or mortgagee, which it does not, there's no reason why it should not operate so as to restrain the exercise of the rights of that person. The exercise of the rights would not infringe the order. It follows, therefore, in my view, that strictly speaking, a chargee or mortgagee in a normal case would not need to obtain a release a release of variation of the freezing order. And then the previous case, which I mentioned, which had taken a slightly different view, decision of Mr. Justice Coleman in Gangway, again, it sets out the facts. And quoted from Mr. Justice Coleman, paragraph 14, where he's considering exactly the same point, whether the holder of the security needs the court somehow to police the exercise of the rights. And he says this: the answer to the question lies in the purpose of this particular jurisdiction. It is not to provide the claimant with security for its claim. That cannot be too strongly emphasized. Its purpose is to restrain the defendant from evading justice by disposing of assets otherwise in the ordinary course of business so as to make itself judgment proof. And he goes on to say his interest is, he then deals with a dictum from Lord Denning, which he set out extensively. Paragraph 16, perhaps, go to. Clearly, if a defendant is entitled to exercise his own commercial judgment in this way, consistently with bona fide conduct in the ordinary course of business, so also must a third party, such as a bank, which has the benefit of a security in the interest in the property covered by the injunction. Its duty in relation to disposal is no higher than to act in good faith in the ordinary course of its business. It should not have to justify its commercial judgment to the court. And then these are the appropriate words. In the absence of evidence that the disposal is conducive or aimed at circumventing the freezing injunction in the interests of the defendant or otherwise not in good faith. And he goes on to say, for the courts to impose on banks any more stringent fetter on their rights to realise security would represent an unwarrantable. And then he says, finally.
Sorry, well, just to pause on that. I mean, that's a reference to what we've been calling the frustration principle.
Yes, it is.
It's a principle outside the terms of the order.
Outside the terms of the order, yes.
Yep.
And then he says, 17, in this case, there's no suggestion that the bank is or might be about to act collusively, otherwise than in good faith. And he finishes off by saying, after the limit of the duty of the bank, he says, provided that it acts in good faith and without collusion in the disposal of the properties in the ordinary course of business, and provided that it holds subject to the freezing injunction any surplus of the defendant's assets remaining after satisfaction of the secured outstanding debt, is acted consistently with its duties. Now, the disagreement between the two judges was over whether the bank had in fact to go to the court, and Mr. Justice Mann went through the authorities, and he disagreed. I don't want to take up time to it.
Well, you don't have time to take up, I don't think. You're very nearly at the end.
I'm very near my end, but it's paragraph 17 there. But what it envisages, there are exceptional circumstances, if I may put it that, which would justify the bank invoking the jurisdiction of the court to get its blessing, particularly in relation to fraud or potential collusion worries.
And just to note also, I'm just looking at the head note, it seems that going back to the debate we had earlier on about whether a bank would seek a declaration or variation of the order, yes. Here, although what's being identified is the limit on the bank's freedom of action created yes. to a limited degree by the frustration principle, one way for the bank to be in the clear was to seek a variation of the order itself, yes. and a variation was ordered to make it clear to the bank.
Yes. Yes.
But, Mr. Justice Mann there seemed to be going further to say that even a sale of the charged property by the bank would not need the consent of the court, whereas I thought that in answer to a question from my Lord Stevens, you previously said, well, yes, the bank would be dealing with realisable property if it sold it, the proceeds of sale, at least insofar as they are the equity. But it may be that is because freezing orders of this kind usually have a term in them which says, of course, anything in the ordinary course of business is not prohibited by the order, whereas the saisie does not have any such term.
No, that's correct. I'm conscious I've trespassed on one of the...
Yeah, so I think you need to conclude your submissions. Was there anything else that you...
No, I've made our submission. We're relying on that other limb, not direct breach of the order, and the fact that on the particular facts of this case, the bank were entitled, if they so wish, to go to the court, and it would not be appropriate to second-guess the bank and say they didn't need to apply for a variation or declaration.
Yes, all right, thank you. Yes, Mr. Cousins.
May it please my lords, my lady. I would like to begin, if I may, with talking about the distinction, or rather talking about the nature of the interest with which we are concerned here. There is, of course, a clear distinction between the holding of a mortgage and the transfer of that mortgage on the one hand, and the realization of property pursuant to a mortgage security on the other. We are concerned today solely with the former. The application which was made to the Royal Court in this case concerned the transfer of the mortgage, not the exercise of the power of sale that a mortgagee to whom a transfer would be effected would undoubtedly have. It is fundamental to property law principles, both in England and in Singapore, that the estates of the mortgagee and the mortgagor are separate and distinct. Anyone with any familiarity of English law land registration, which has been running, depending on where you are in the country, but certainly since 1925, knows that there are various divisions of the land register which separate title, proprietor, charges of a mortgagee, and other interests with which we're not concerned today. It's the same in Singapore. Under the Singapore Land Titles Act, the title of mortgagee and mortgagor are separately registered. We've put into the bundle the provisions of the mortgage register, and you will, in Singapore, you will find it at page 676. And you can see there, it's actually slightly more compressed than you would find it in its English equivalent, but you can see there very clearly that the mortgagor is described as Jean Zell and the mortgagee as Credit Suisse. And the provisions of the relevant legislation in Singapore are identified in paragraph 20 of our case, which is at page 1676. And if I may, I will go to page 1676 because it brings into that one paragraph the relevant principles of land law in Singapore which are applicable to this case. Jean Zell was the registered proprietor of Cascaden, the bank the registered mortgagee. We see that at page 676. The proprietors of such interests hold them free of other interests, save as are noted on the register. That is for section 46 of the Land Titles Act of Singapore. You will find that at page 738 in the bundle.
Do you want us to look that up, or is that just
if you're happy to take it from me, I don't need to take you to it further. The transfer of a mortgage in Singapore and its effect is regulated by section 63 and 64 of the Land Titles Act of Singapore. They are conveniently set out at the foot of page 1696 in our written case. It is important to look at this because these are the undoubted powers of a mortgagee in Singapore, the undoubted powers that the bank had in this case when it granted the mortgage. Subsection 1. The proprietor of an estate in land or of a lease or a mortgage may transfer the same by an instrument of transfer in the approved form, and upon the registration of such instrument, the estate or interest of the transferor as therein set forth, together with all easements, rights, powers, belonging or appertaining thereto, pass to and are vested in the transferee thereof as proprietor. 2. On the registration of any transfer of a mortgage or charge, the transferee becomes entitled to all of the rights, powers, and remedies of the mortgagee or chargee expressed or implied in the mortgage or charge, including the right to recover any debt, sum of money, annuity or damages, even though the same may be deemed or held to constitute a chosen action, and all interest in any such debt, sum, money, annuity or damages vests at law as well as in equity in that person. So all of those rights and powers were vested in the bank.
I don't think any of this is disputed.
No, my lord, it isn't. But this is of fundamental importance, and for this reason, that those powers are powers which are separate from the power of sale, which arises under Singapore law, as it does under English law.
But it's not inconceivable, is it, that somebody could take a transfer of the mortgage with the intention, collusively with the criminal, of selling it at an undervalue and allowing assets to be extracted in that way?
I accept that entirely.
Well, then there's nothing wrong with the court refusing to grant a declaration that gave an absolute blessing to any assignment that the bank chose to undertake.
My lord, there are these impediments in the way. Could I take you, please, to...
Before we get on to the impediments, you accept the proposition that it would be a contempt of court to frustrate the order of the SESI.
Well, assuming, of course, that the SESI is applicable and enforceable in Singapore, making that assumption, let's make it nice and simple. If this were a Jersey property, a Jersey mortgage, then would it be a contempt of court for someone to frustrate that? Then yes, of course it could be, in just the same way as it could be in England under the Taylor principle, to which my friend has taken you this morning.
The Court of Appeal were incorrect not to consider the potential frustration.
Well, my lord, I'd say not. For this reason, we need to look. We need to look at what the SESI, what the powers under Article 16 confer upon the court. Could I invite you to look, please, at Article 16? I'll give you the page reference in just a moment. Yes, it's at 2122. The court may grant a SESI, subsection Article 1, 16.1, but if I may move on to 4, subject to para 5, on the making of SESI judiciaire, all the realisable property held by the defendant in Jersey shall rest in the Viscount. That's of no relevance. B, any specified person, and I emphasise the bank wasn't a specified person, may be prohibited from dealing with any realisable property held by that person, whether the property is described in the order or not. It is common ground, in this case, that the bank held no realisable property. There was, therefore, no power to restrain the disposal by the bank of its property and its property alone.
I think that's accepted by the Attorney General now.
My Lord, that being the case, our submission is this. The right step in the circumstances.
But before we get on to that, doesn't it frustrate the order that ought to, or properly should have been made, preventing the specified person, not the bank, but the holder of the legal title to the apartment, from dealing with it?
Well, my Lord, no, it doesn't. What would frustrate the order of the court would be the collusive disposition of the real estate, the freehold in the property itself. What would the transfer of the security would not be the frustration.
That might just be a precursor to the second.
Well, it might be, but it's an essentially different step. The question...
But I mean, on that, it's a different step, I can see that, but potentially it would be a step which would be caught by the frustration principle, would it not?
But My Lord, this goes to the question of the power.
I'm so sorry. I've just been handed a note saying that our live stream has ceased to operate. If you wouldn't mind just pausing before you answer that question, I just want to check. What's the time scale?
Thank you.
Yes, so audio is continuing. Nothing's happening. Could you check how long they think the problem's going to last? Yes, I'm sorry, Mr. Cousins. We lost the visual feed about 5 minutes ago, but the audio feed continued. But now we've lost all feed. And so I'm just making inquiries to see how long the problem is thought it will last. So if we could just pause until I get that information. We may have to adjourn for a short period to enable this to be sorted out. I'm very sorry. I've been told it'll be about 5 minutes or so. I think rather than have us sit here in silence, we'll adjourn briefly, but expect to resume very shortly. Thank you. Yes, thank you, Mr. Cousins. You've lost 5 minutes. We'll add it on.
I'm grateful.
Keep going.
My Lord, the point I was about to make is that there is simply no power under Article 16 to prevent a bank from assigning a mortgage.
I think that's accepted.
Well, I'm grateful for that. The correct way for the authorities to have gone about preventing a collusive transfer of the mortgage would have been in Singapore, we would submit, but they could have done two things. They could have followed up on potential remedies available under the laws of Singapore to protect their position. And these are enumerated.
But it wasn't that the authorities were seeking anything from the court. It was your clients who were asking the court to say, no matter what the circumstances of the transfer, even if it's collusive, you won't be in contempt of court, basically. And the court wasn't prepared to say that. It couldn't. So it didn't refuse the declaration that was sought.
Well,
that was all that happened.
The position of the beneficiaries was that, and they even adduced expert evidence, or sought to adduce expert evidence before the Court of Appeal. It wasn't actually referred to. Leave to admit it wasn't refused, but it wasn't actually referred to, though it is in the bundle, and it's been referred to by both sides for the purposes of this appeal. The beneficiaries were saying, in Singapore, there are protections available which would reduce any risk or eliminate any risk of a collusive transfer, because the SESI could be registered in, an application could be made to register the SESI under the laws of Singapore, a caveat could be lodged, or a deposit of title deeds could be taken. We enumerate all of those at the top of page 1677. They're extracted from the expert report which was obtained and was before the Royal Court, and those measures are described in para 914 of the expert report obtained from Singapore from a conveyancing lawyer, Mr. Ting.
But despite all that, you've accepted that it would be a contempt of the SESI if there was a collusive assignment.
If there were, the assignment itself, in my submission, in this case, was never going to be a collusive assignment. The assignment was an assignment being undertaken by a financial institution whose good faith was not in question. If some other party, having taken the assignment, then misused the security which it obtained on established principles, that would be the contempt. But it would not be a contempt for Credit Suisse, in good faith, to execute an assignment to a third party.
Well, that may be so, but Credit Suisse, being a cautious bank, doesn't want even to have the possibility of someone coming back against them and saying, oh, you knew X, Y, and Z. In the light of that, in fact, you did know sufficient to engage the frustration principle. I mean, that's why my Lord Legate is pointing out that the application which we're concerned with is not an application by the Attorney General seeking to actually enforce in contempt the SESI against the bank. The background is the bank won't move by itself because it doesn't want to have any suspicion or any possibility of contempt proceedings perhaps being launched against it, however improbable that may be. And your clients then go to the court and seek to a declaration which in effect says whatever the circumstances, the bank cannot be liable in contempt. And since liability in contempt must depend upon the circumstances, I mean, it may be improbable, but there is the theoretical possibility. I think it's being put to you that the Royal Court was right to refuse the application that your clients were making.
My Lord, I understand that's what's being suggested, but the point which the beneficiaries were pursuing was that it would not be a breach of the SESI in itself for the mortgage to be transferred. And
not of the SESI itself, that's accepted, but it might be a breach of the frustration principle, which applies in respect to the SESI.
But that would, but in order for that to be engaged, there would, in my submission, it would have needed to be demonstrated against the bank that the bank was acting in bad faith.
Yes, it would. Banks are very protected. This bank may have been unduly cautious.
Yes.
As you say, the chances of it being found liable for contempt on the basis of the frustration principle might be remote. But banks aren't required to take even that risk. And you, as I understand it, the logic of the application that your clients were seeking was to try to persuade the bank, if they got that, the application successful, would be to seek to persuade the bank that there was no risk in any circumstances of the bank being held liable in contempt on the basis of the frustration principle. How could the court give that carte blanche to a bank when potentially it could be liable, maybe remote, but potentially it could be reliable, depending on the facts, for breach of the frustration principle in respect to this order?
My Lord, what was being asserted on behalf of the Attorney General was that the SESI prevented the assignment of the charge. The question of these authorities about the frustration principle and so on were not engaged in the argument before the Royal Court. The case was put on the basis that this was a frozen asset. It was realisable property. That was the basis upon which the Royal Court refused the declaration sought.
I thought that we'd see that there's, a degree of tension, if you like, in the reasoning of the Royal Court at paragraphs 32 to 34.
If I might just go back.
Then again, in the reasoning of the Court of Appeal, particularly at paragraph 56, because both do refer to what we're using as shorthand, the frustration principle, as being an applicable principle, as well as considering the construction of the SESI itself.
But the basis upon which the Royal Court refused the declaration was that the mortgage security was realisable property.
That was certainly one basis in paragraph 34.
Yes, if I might just get to that.
But in paragraph 32, and this is the tension, if you like, it says, in the exercise of its powers, so this is page 128, Cousins, in the exercise of its powers, the court is concerned with the preservation of the value of that equity.
Yes.
In the asset.
Yes.
So the asset in the trust is the property, and it's the equity in that asset that should be available to meet any confiscation order. In the exercise of its powers, the court is concerned with the preservation of the value of that equity. So that's looking forward to what the order is supposed to achieve. And then in paragraph 33, it's explaining, in very truncated form, but it's saying that the way an order like this binds the bank, that is to say, potentially gives rise to the possibility of contempt on the part of the bank, is that it has notice of the order, and the frustration principle might apply.
My Lord, if it is permissible for the duties or the risks to a bank to be interpreted as widely as is suggested, it would have the most horrendous implications.
Forgive me, I don't think it's being suggested that the potential liability of a bank is interpreted widely. Indeed, the frustration principle, as appears from Taylor and the Gangway case, operates in very, very limited circumstances. So at the moment, I don't think that it's being suggested that the frustration principle operates any more widely than is already a matter of established law, and it's very narrow.
What, if I might make this submission, if I could come at it from a slightly different angle, it's very important that banks internationally do not have to fear that they might be inhibited at some point in the future from assigning their mortgages at will, because it could be suggested against them that the assignment of a mortgage in itself amounted to the breach of a SESI or its equivalent in another jurisdiction. In our case, we give a few examples of this, but could I just take perhaps the simplest? As I'm sure the board will know, many large banks across the world have hundreds of thousands of mortgages on their books. Not infrequently, some banks decide to get out of the mortgage business or decide to get out of the mortgage business in a particular territory, and they might want to sell a whole book of mortgages, perhaps tens of thousands at a time. Now, if they want to do that, they need to know that they're free to do that without the risk of someone saying you can't sell your mortgage book because there is a mortgage over a property in Singapore on the book, in respect of which the Jersey authorities have an interest by way of the saisie judiciaire. Think of the implications of it. One of the implications...
Or just to expand the example, or that there's a worldwide freezing order granted by the courts in England and Wales, or any other jurisdiction. So it's not just about the impact of a saisie judiciaire. we're talking here about the impact of the law of contempt across a range of jurisdictions.
My Lord, there is a particular problem, though, with the saisie judiciaire, and in the context of this case. Here, one could have a situation in which a bank wishes to dispose of its mortgage book. It's held up. The transaction is held up because of a single judiciaire, saisie judiciaire, issued in Jersey, perhaps some time before.
Wouldn't the bank just take out that one mortgage property?
Well, that is.
Yeah, I wouldn't say it's the way it would need to. I think it would be important to make it clear. It's hard to conceive that the bank could possibly be liable if it sold its whole mortgage book like that. Well, it could be said it was in contempt in relation to one transaction which it didn't know about and within that book.
It's hardly selling it to a criminal if it's selling it.
Yes, but if it's just a part of a commercial bona fide sale.
Well, I'm so sorry, but to add to that, isn't that why the criteria for liability on the frustration principle, as we've been calling it, are so very, very restrictive?
Yes.
That's to reflect the points that you're quite rightly urging on us, that banks ought not to be readily prevented from proceeding with commerce in an entirely conventional way. But, and again, I have to press you on this, the theoretical possibility of that principle being engaged in respect of a bank which is transferring its security interest, I think you've already accepted, is there.
Well, of course I accept that by assigning a mortgage, it could ultimately facilitate a collusive transfer. But in my submission, it's very important in terms of the value of mortgage security to lenders, particularly in the world of mass securitization of mortgage securities and onward disposal, that banks know that there is a bright line distinction between the transfer by assignment of a mortgage and becoming involved directly in a collusive disposal in an individual case.
Well, unfortunately, there isn't. If you know that the person to whom you're transferring the mortgage intends to exercise his rights so as to defeat a freezing order, then you are at risk if you transfer the mortgage.
My Lord, that wasn't the evidence in this case.
So be it.
But the submission that we make is that in this case, the appropriate course, if the Viscount feared that the property were at risk, and the Viscount, if the Attorney General is right and had the right to this asset, would have had an interest in the proceeds of sale of the property, the Viscount could have applied in the courts of Singapore for an order to restrain, if the evidence was there, the sale of the property.
It didn't need to, because the bank didn't want to transfer the property to whatever his name was.
It's your clients trying to persuade the bank. I'm so sorry.
Yeah.
That they're completely risk-free, completely. And they were hoping that they get an order from the court which essentially said you are completely risk-free, whatever the circumstances, and they would take that to the bank and say, you're in the clear, please now do this assignment.
Well, my Lord, I submit that the bank was entitled to know, and under the wording of Article 16, should have known, that it was, so far as the mere transfer of the mortgage was concerned, risk-free.
Well, in a sense, the bank, if the bank had wanted to proceed with the transaction, one could see the force of that, because then the bank could have come, as happened, I think, in the Taylor case, come to the court and say, well, all sorts of things have been alleged about the possible transferee. Nothing to do with us. Here's our evidence. Attorney General, put up your evidence to dispute that. Otherwise, please, court, either make a declaration or vary the order to make it clear that we can proceed. But that wasn't what the bank was. The bank wasn't seeking to do that. So the bank wasn't coming to the court with its evidence and saying, there's no way that the frustration principle applies to us in these circumstances. It was your clients trying to persuade the bank to proceed on the basis of a declaration by the court that there was no possibility in any circumstances of the bank attracting liability and contempt on the basis of the frustration principle.
My Lord, the factual background here, we have set out in our written case.
It's actually very hard to see any possible intention for the transaction except to prevent the realisation of the asset.
My Lord, I'm sorry, I didn't quite...
It's very hard to conceive of any possible intention of the assignment that was proposed to an old friend of Mr. Tantular, except to frustrate the realisation of the equity in the property.
My Lord, I'd respectfully submit that's not right. The position here was that there was a valuable property with equity in it. Mr. Koswara, who was prepared to take the assignment, was trying or wanted to help protect the family of a friend of his. He didn't have to become involved criminally to do that. He was prepared to take this on as a commercial deal. He had security. He would have obtained interest. He had a perfectly legitimate reason for wanting to do what was proposed. And it wasn't actually suggested by the Attorney General that this was a fraud.
And how does the Viscount get the proceeds of sale then? If you're protecting the interests of the family?
The Viscount would still have an interest under on the Attorney General's case. The Viscount would have an interest in the property.
In the apartment?
In the proceeds of sale. If there were a collusive sale, the Viscount would be able to claim, in Singapore it's called damages, and in the equivalent situation here we would call it equitable compensation.
Never sold the property.
I'm sorry?
The friend would never sell the property. There would be no proceeds of sale.
Well, if that were the case, there would be no risk to the Viscount. The Viscount... This brings us back to the matters that we were debating yesterday. If the Attorney General's case is correct, the Attorney General would be able to procure an interest in the property and bring about, through that interest, a sale of the property. So that way, the Attorney General, or rather the Viscount, gets his hands on the proceeds of sale. If the property were collusively sold off and the Viscount didn't manage to get his hands on the proceeds of sale, if the property was sold off at an undervalue, the Viscount would be able to say in the courts in Singapore, and there's Singapore authority as well as English authority on this, the person effecting the sale, the mortgagee effecting the sale, is liable, as we would say, for equitable compensation, or is under the Singapore authority for damages. And there is actually Singapore authority on this very case.
I see your point. You're saying that the Attorney General had no right that the bank should do its work for him, as it were, or that the mortgagee should do its work for him by selling the property.
Yes, my Lord, I say that, and I say that there was actually no financial risk here to the Viscount, because the Viscount, if the Attorney General is right, would have got his hands on the proceeds of sale by his procuring a sale of the property, and if a mortgagee competent or incompetent, collusive or otherwise, had sold the property improperly, there would have been an action for damages or equitable compensation.
I mean, if Credit Suisse hadn't wanted to sell the property, the Attorney General couldn't have complained about that. And so if it were the intention of the assignee not to force a sale of the property, there's nothing wrong with that. I can see that point.
Well, that's what we say.
So the Viscount, so in that scenario, the Viscount using the powers under the modified law to realise, to liquidate the realisable property could have forced the sale itself.
Yes,
and paid off the debt, and then used the proceeds, the excess proceeds which represent the equity, into the fund that you showed us yesterday.
If the attorney is right, if the attorney is wrong, and he had no claim on this Singapore property for all the reasons that we were advancing yesterday, if the attorney is wrong, well, he can't complain. He's lost nothing. Now let's suppose the attorney is right. The attorney is entitled to the equity in the property. He's entitled to the proceeds of sale of the property after any proper expenses have been paid off. That being the case, he can secure his position in Singapore by entering notices, caveats, and all those sorts of things, just like they could in England.
But it's just his good luck that the mortgagee was proposing to do his work for him, as it were, in this case. And he couldn't have complained if, for example, Credit Suisse had changed their minds and said, we're not going to sell it.
So
the loan might not have been in default, might have been paying the loan.
Yeah.
And then there would be no right of sale.
Well, that's...
Could I just go back, because this takes us back to topics that we were looking at yesterday. And this is a very good reason, in fact, for why local enforcement is appropriate rather than enforcement from a jurisdiction on the other side of the world. This is a mortgage over a property in Singapore. Our case is that the authorities in Singapore could have been asked to take the steps, the equivalent of a saisie, under the Mutual Assistance Act in Singapore. The Attorney General in Singapore, under Section 29 of MACMA, the Mutual Assistance in Criminal Matters Act, the legislation's in the bundle, I can give you the reference if you want it. If the Attorney General of Singapore had been asked to take steps, he could have sought a saisie or I don't think it's called that in Singapore, a freezing order or whatever it's called there, and frozen this asset, and he would have been able to make an assessment on the spot. That isn't the only protection that would have been available for the Viscount, because the Viscount independently could have said, we want to be protected. We have a claim by way of the saisie. I am ultimately entitled to the net proceeds of sale. I want my interest registered, and I fear that I demonstrate on proper grounds that would justify a quiet time at injunction, I fear collusive disposal of this property. I want an injunction. He could have done that. And that points to the desirability of allowing and requiring, not merely allowing, but requiring that these matters are dealt with in the local territory, where the local law can be applied. This mortgage was subject to the law of Singapore, necessarily. And in our submission, that was the right way to have gone about this from the start, if remedial steps were to be taken, to take them in Singapore, put the matter under the control of the Singapore courts, and the Singapore courts could decide how this property should be dealt with so as to secure the objectives of preventing dealing in the proceeds of crime. Just looking for a moment at the merits of all of this, though, if I may just spend a very short time on this. Everything about this application that was pursued in the Royal Court was gone about properly. The beneficiaries were completely open months before the application was made about what they wanted to achieve. an application was made to the court, and evidence about the intended disposal of the property, of the mortgage, was put before the court. When the Attorney General objected to it, expert evidence was obtained by the beneficiaries, and only by the beneficiaries, about what protections could be available in Singapore. And it's perfectly apparent that absolutely nothing had been done in Singapore to explore the situation with regard to availing the Attorney General or the Viscount of such protections. In those circumstances, in our submission, to block this transaction at the stage of assignment of the mortgage was not only impermissible under the terms of Article 16, it was going well beyond any reasonable protection that was required for the benefit of the attorney or the Viscount. Might I have just one moment? Sorry, I've got the wrong volume. Yes, the background to all of this is set out in the written case at page 1670, paragraph 4 and onwards. Paragraphs 4 to 6 set out the background and the steps that were taken to provide everybody with the relevant information about
This the page number.
It's 1670, and it's paragraphs 4 to 6. It's paragraphs 3 to 6 at 1669.
Can I just pick you up on the language that you used just before you turned up that reference? You said
Yes.
to block this transaction at the stage of assignment of the mortgage was well beyond any reasonable protection required for the Attorney General or the Viscount.
Yes.
I think it's being put against you that the order wasn't directly binding on the bank. What is doing the blocking is the frustration principle.
Yes.
So when you say to block this transaction at stage of assignment of the mortgage, I mean that's a bit like saying the frustration principle cannot apply where that's what is doing the blocking. But just to repeat, but you accept that the frustration principle does apply in principle.
Well, it could do if it were demonstrated against a bank that it had become collusively involved in an assignment with a view to a fraudulent disposition of the property.
I didn't think you did accept that. I thought that you were saying, no, an assignment of itself can never, even if to a crook, can never damage the value. It's only the subsequent sale or the subsequent refusal to sell.
My lady, that is what I say. But
Right.
of course, if it were proved that a bank had quite deliberately become involved in making an assignment with a view to an onward collusive sale, well then, the bank itself.
But maybe then at the time of the sale, then the bank could be drawn into any liability, or after the sale, as it were, one could see.
Well, the bank itself would. A bank that's acted in good faith simply by assigning could never be affected by the frustration principle. It's only what happens after
Yes, that's what I
the
thought.
assignment has taken place that could involve the bank. So it would have to be alleged against the bank, and it wasn't being alleged against the bank, that the bank was part of this collusive process. Now, if the...
But that's because the Attorney General, there wasn't a proposal by the bank to effect an assignment, and the Attorney General was not involved in trying to stop the bank from doing anything. The bank wasn't willing to proceed itself, and your clients were trying to get to a position where they could persuade the bank that there was no risk to it at all, and therefore it could proceed.
My Lord, I appreciate that, but the bank did not go, the Attorney General did not go to the Royal Court and say, we maintain that it is appropriate to deny the declaration because the Attorney General suspects that the bank is part of a collusive transaction in considering making the assignment to Mr. Koswara. That was not the case that was being advanced. Now, if it is accepted that the bank was not on the wrong end of an allegation of collusion, there was no basis for saying at any stage that the bank might be at risk because of the frustration principle. And once that is excluded, there is no possible justification at all for using Article 16 to prevent, even to suggest that the bank might be at risk.
Well, these might all be good points to put to the bank. The beneficiaries could have said all these things to the bank and said, look, you're so far away from any possibility of liability in contempt on the frustration principle that you can just proceed. In effect, you are risk-free. But the bank wasn't willing to proceed in these circumstances.
In the Royal Court, the bank wasn't allowed to proceed because the Royal Court held that the mortgage was realisable property. In the Court of Appeal, the Court of Appeal held that it wasn't realisable property, cutting away at the whole foundation of the Royal Court's decision.
Was that the only point relied on in the Court of Appeal? Do you say the frustration principle didn't enter into the argument?
It didn't, no. There were two matters before the Court of Appeal. In fact, it was only the question of the assignment of the mortgage and whether the mortgage was realisable property that was decided by the Court of Appeal. The Court of Appeal also said that it didn't deal with the alternative application, which was to vary the saisie judiciaire so as to allow the transaction to go ahead, because that didn't arise once the Court of Appeal held that the assignment of the mortgage could go ahead because the mortgage wasn't realisable property. That didn't arise. The Court of Appeal did not consider, when it indicated that it wouldn't have been minded to grant a variation of the saisie, it hadn't considered all of the other material that had been adduced by way of the expert report and the other arguments that had been put forward to show that there was, in fact, ample local protection in Singapore for the position of the Viscount.
But just looking again at 686, at the wording of the declaration that was sought.
Sorry, page 686?
Yes, it's like a halfway house between a declaration that was entirely a legal principle. So you could have asked the court to declare that a saisie judiciaire imposed upon the realisable property of a person does not prevent a bank from assigning to a third party its rights under a credit facility. It could have been just presented like that.
Yes.
Or it could have been presented, doesn't prevent Credit Suisse assigning to Mr. Koswara its rights under the credit facility. Now, I think you accept that if it had been specific to Mr. Koswara, then subject to the point you just made about the Court of Appeal not having all the, or paying attention to all the information about the fact that he was a perfectly respectable person, but as at presently advised, the Court of Appeal would have refused that. What I'm not sure is whether you're saying that if it had been entirely neutral as to whoever, and it had just been presented as a legal consequence of the scope of potential saisie judiciaire, whether you are saying that that ought also to have been granted.
The submission that we're making today is that on the concessions that have been made today by the Attorney General, what is in this summons ought to have been granted. Thank you. Might I just have a moment?
Yeah.
Sorry, what did you say, Tim? Right, thank you very much. Could I have just a moment, because my attention's been drawn to something. Yes, my lady, going back to the summons to which you drew attention a moment ago, I submit that the answer to the question posed by the summons, which was whether the saisie judiciaire prevented the assignment to the bank, was that no, it didn't, which is the answer that the Court of Appeal got to. And it isn't the terms of the saisie judiciaire that prevent the assignment. The matters that we've been considering in the last few minutes have been collateral matters which would follow upon the assignment, namely the risk of a collusive disposal and how it might be suggested that the bank was involved in that. But it was never being suggested that the bank was involved in a collusive disposal. So there was nothing at all in the issue raised, the primary issue raised by the summons.
And you say that what was being argued by the Attorney General was that actually the order itself prohibited what the bank wanted to do. And that was the argument that was presented, not that, you can do it, but that there is a risk of contempt.
That's exactly what we say.
He took his stand on the fact that this is all one property and that kind of thing. Those kind of points.
Yes, this whole question of collusive, of frustrating the order on the part of the bank is something which has come up subsequently. The answer to the question, in the primary part of the summons, does the saisie judiciaire prevent an assignment? The answer must be no, because this is not realisable property.
It depends how widely you read the declaration that is sought, whether it's just referring to the terms of the saisie judiciaire or whether it's referring to the effect of the saisie judiciaire more widely. And it might not be said that the way that it's put invites the wider interpretation. I mean, I follow we haven't been shown precisely what arguments were being presented, but just looking at the summons, it's a declaration that the saisie judiciaire do not prevent, whereas they may prevent, depending on the circumstances, in light of the frustration principle.
My Lord, the saisie judiciaire prevents dealing with realisable property. Nothing more. If the mortgage itself is not realisable property, then dealing with the mortgage cannot possibly amount to dealing with realisable property. It's as simple as that. In our written case, we've used this analogy. There are all sorts of prohibited substances dealing in which can give rise to criminal liability, drugs being one example. If a transaction does not involve dealing in drugs, there can't be a dealing in drugs. If the mortgage is not realisable property, which is all that the saisie judiciaire precluded, transferring the mortgage can't possibly amount to a breach of the saisie, and therefore it's not caught by its terms.
Yes.
Sorry, could I just have a word with Mr. Hanson?
Of course.
Thank you. Yeah.
Hang on.
Yes, yeah. That's thank you.
You, in answer to Lady Rose, this question, which is the form of the declaration sought, whether that was a factual one relating to Mr. Koswara or presented as a legal consequence, and that is does not prevent on the terms of the order. You always answer the factual one by reference to the bank. Only are the bank potentially frustrating the order. But of course, Mr. Koswara also was on notice of the order.
Yes.
And so he could also potentially be in contempt.
If Mr. Koswara were on notice of the order and intended to act fraudulently, collusively, then Mr. Koswara might have something to fear, but he could not do anything until he had taken an assignment of the mortgage. He wasn't in a position to sell anything until an assignment of the mortgage had occurred. It's not the transfer, the mere fact of transfer to him that assists.
I was just wondering how a court would grant a declaration that a particular assignment was not in contempt of court if one of the parties to it was acting collusively or frustrating.
Well, my lord, if I could answer that by reference partly to the factual background, which is set out in paragraphs 4 and 5, materially, in our written case at page 1670. They set out the discussions that are taken between the beneficiaries and the bank, the identification of Mr. Koswara as somebody prepared to take an assignment, and it was the respondents who suggested that the sanction of the Royal Court might be sought for the proposal, circulated details of Mr. Koswara and a CV so that due diligence inquiries could be made by the other parties, hoping that the parties would work collaboratively. Then in paragraph 5 we go on, despite repeated requests made in writing and by telephone, in which the view was stated that the saisie were required to be clear but did not on their face appear to prohibit a transfer of the mortgage, the Attorney General did not respond substantively until after the summons was issued. And it was only then that the attorney wrote a letter of objection addressed to the bank's advocate in St Helier, referring to the saisie, and he objected to the transfer on the basis that any assignment to a third party of its rights under the credit facility and the legal mortgage would require a further variation of the saisie. He expressed concerns about the transferee and asked for his objection to be passed to the director of the bank in Singapore. And then in the first affidavit of Mr. Tan, one of the respondents, he maintained that the mortgage was an asset of the bank, couldn't represent realisable property situated in Jersey of Mr. Robert Tantular, and that they were entitled to seek to preserve their home at the interim stage given the continuing delay in the resolution of the proceedings, and the matter was then brought before the Royal Court. I come back to the position that there was nothing before the Royal Court which would have begun to justify a quietimate application for injunctive relief in respect of restraining disposal or a sale of the mortgage property. No, there was nothing of that kind before the Royal Court. The information before the Royal Court was that there was a charge. It's now accepted that that charge wasn't realisable property and therefore couldn't in itself be caught by the provisions of the SESI. All that the attorney can do is say, well, there might have been ultimately a collusive sale. And our answer to that is, if that had been a fear backed by evidence sufficient to justify a quietimate injunction, an application could have been made, had it ever been necessary, to the courts in Singapore, or the position of Viscount could have been secured locally in Singapore. I've already made submissions about how this fear of risk could have been avoided by the making of an application for assistance in Singapore rather than in Jersey, and why that, in our submission, would have been the appropriate course. And the Attorney General has fairly, in his submission, accepted that Mr. Kaswara had given an undertaking, had offered an undertaking to cooperate with the authorities to make the necessary arrangements for the protection of the bank, for the protection of the Viscount.
Yes.
That is, in my submission, extremely material when looking at the entire position.
So, Mr. Cousins, even with your additional 5 minutes, you're within about 2 or 3 minutes.
My Lord, I think I've said all I want to say,
right.
But I just checked with those either side of me.
Of course.
There's nothing more. Mr. Hanson points out correctly that if you look at page 115, there is recorded in the judgment of Mr. Clyde Smith, at first instance, the totality of the summons in terms of the relief sought, the declaration, and the alternative proposal that the SESI be varied so as to permit the particular assignment. So that was an alternative proposal. The focus being on a proposal for there to be an ultimate transfer, but the SESI had two distinct limbs. I'm sorry, the summons had two distinct limbs, as is set out in the judgment of the Commissioner. I might have just asked Mr. Smith if there's anything else. Two points, if I may, which Mr. Smith has identified. First is this: if this had been done in Singapore rather than in Jersey, the Attorney General of Singapore, under Section 29 of the local legislation, the Mutual Assistance Act in Singapore, would have been involved and would have had to take his own view on the appropriateness of taking action. We say, of course, that that is the right way that it should have been gone about. The other point is, in answer to a point raised by my Lord Leggatt, with regard to worldwide freezing injunctions, the point there, of course, is that no person outside of the jurisdiction of the court can be liable for frustrating a freezing order except the defendant. Unless I can assist further, those are our submissions.
Thank you very much. Yes, Mr. Thompson.
Two matters only arising from that. The first is the suggestion that there were evidence before the Royal Court was satisfactory and would have enabled the court on a variation application to be able to say yes. May I just refer the board to page 128 of the electronic bundle, paragraph 35, which is the facts as seen and as judged by the Commissioner before the Royal Court. So having dealt with the mortgage point, he goes on to deal with the second application in relation to the variation. So as to allow the bank to exercise that power, this is going back to the earlier judgment in relation to the mortgage and the power of sales. It was allowed because it was a bona fide arm's length transaction. But this is what the judge said. What is now proposed is that this same power will be assigned to Mr. Kusawara, an old friend of the settlor who resides in Indonesia, where the settlor also resides, outside the jurisdiction of both this court and the courts of Singapore. There has been no disclosure of communications between the settlor and Mr. Kusawara, or between Mr. Kusawara and the applicants, or as to the source of the $4.6 million that would be used to acquire the mortgage. The court has no confidence that it knows the full terms of the arrangements, and it's manifest that placing Mr. Kusawara into the position of power over the property could be highly prejudicial. And in fact, when this matter came to court, in the Royal Court, the proposal was that the mortgage should be transferred to a special purpose vehicle. At the time, no jurisdiction had been nominated, so it's hardly surprising that the court took the view that there was insufficient information to justify any variation.
So I can see that that argument seems to reflect some of the pre-hearing correspondence.
Yes, it does.
601, 602.
That's right.
Were there skeleton arguments before the Royal Court on this point and skeleton arguments before the Court of Appeal?
There were skeleton arguments before the Court of Appeal, certainly, yes.
And where do we have those? Because I think it's
They'll be in
a point against you is that by the time the matter came on to the Court of Appeal, you weren't relying on the frustration principle
Yes.
at all, so there just wasn't any argument about that.
Well, is it true that you never relied on it in the lower court, and that this has been introduced for the first time on this appeal, and that none of the case law about Justice Mann and so forth, it wasn't put on that basis? The only way it was argued was that it was said by the Attorney General that the terms of the SASE themselves prohibit this transfer, and it would be a breach of those terms.
I accept that's the main way it was put, but it seems from
When you say the main way, you'll be asked, was that the only way that it was put?
May I, over the adjournment, just look at the submissions that were made?
I mean, having seen how they summarise the arguments, it looks that way, but...
Yes. May I do a double check?
Yes,
Thank you.
but you had the second point.
Oh, sorry, yes, this was in relation to a point raised by the court about whether there should be a variation or a declaration if a bank were in an awkward position. The only point I'd make, it's an authority, it isn't in the bundle, but we looked, it's the case of the Attorney General against Punch, 2003, one appeal cases, 1046. Paragraph 44 of Lord Nichols' judgment.
Sorry, do we have this in?
No, we haven't, but that's why I'm giving the reference.
Can you give us the reference again then?
Yes, 2003, one appeal cases, 1046 is the start of the case. It's paragraph 44 of Lord Nichols' judgment, where he says the appropriate remedy for the third party is to apply for a variation of the order. That's the other, that's the point.
did you refer to in your case?
We referred to
Well,
it in the
56.
case, but we didn't actually put it in the bundle in the end.
Yes, and can you assist us with bundle references for where we find the skeleton arguments in the Court of Appeal, please?
Yes, they're in the, should be in the record of the proceedings, if I can just come out of the bundle of authorities.
I think it's at 1478.
It seems Mr. Mahoney has found some of the references. It's 148 to 153, and then again contentions in reply 218 to 224. Yes. Oh, we'll just double check. That's the complete.
Right.
I thought it was at 154, the first Attorney General's arguments. Maybe that's a different appeal.
Yes, your Lordship's quite right. There's a whole series of them, 154 to 176 is. The trouble is there are rather a lot of them because a lot of the appeal was taken up with an argument.
Whether it should be argued at all.
Yes.
Yes, was there anything else?
No, that was it. Thank you, my Lord.
Well, thank you very much. We'll adjourn there and we will resume at 2 o'clock for the third of the appeals, which is the immunity appeal. Thank you very much.